Welcome everyone to the Assembly Committee on Legislative Operations and Elections. Whoops, I guess I need to gavel in. Sorry. Madam Secretary, please call the roll.
Assemblyman DeLong.
Present.
Assemblywoman Dickman. Assemblyman De Silva.
Here.
Assemblywoman Gonzalez.
Here.
Assemblyman Hibbets. Assemblyman MacArthur. Assemblywoman Brittany Miller.
Here.
Assemblyman Cameron C.H. Miller.
Here.
Assemblywoman Monroe Marino.
Here.
Assemblywoman Newby.
Here.
Assemblyman Yeager. Chair Gorlow.
Here. Thank you very much. Please mark Assemblywoman Dickman and Assemblyman MacArthur present when they arrive. They're in the Senate presenting right now. I'd like to welcome everyone again to the Assembly Committee on Legislative Operations and Elections. Today we'll be hearing two bills. We'll be hearing Senate Bill 354, which revises provisions related to justices of the peace, and SB 418, which revises provisions related to candidates of the office of district judge. Some quick housekeeping before we get started. Please remember to silence all your electronic devices. If you would like to testify or come up for public comment, please make sure that you're pressing the microphone and then stating and spelling your name slowly for the record. You may also sign in, which will help the committee secretary know who is presenting. We will be using our laptops and sometimes our phones, so that's just so we can look at materials and communicate with each other. Please do not take that as a sign of disrespect. And with that, we will get started, and I will call Senator Scheibel to the table. Welcome. I believe we'll be starting with SB 354 first, so please begin when you're ready.
Perfect, thank you. And thank you so much for taking the time to hear both of these bills this afternoon. My name is Melanie Scheibel. I'm the state senator for District 9, and today I have with me Elliot Mallon from Alpine Strategies to talk about SB 354. SB 354, as you can see, has really only one section to it, so I won't do a long walkthrough of the bill, but I will walk through kind of the history of the bill and what the bill is intended to do. Nevada is a unique state in that we have we do not have a unified court system. Our court system includes municipalities, it includes justice courts, and it includes district courts. The judges who preside over the justice courts are called justices of the peace, and they are judges of limited jurisdiction. That means that they can't hear felony trials, they can't hear cases that in civil matters that rise over $10,000 in value, and they can only hear cases within their physical jurisdiction. In Nevada, in 2015, we passed a law that no longer requires those individuals to be members of the State Bar Association. So you do not have to be an attorney to be a justice of the peace in the state of Nevada. The purpose of SB 354 is not to make any changes to that scheme. The purpose of SB 354 is to provide every person in Nevada who votes for a justice of the peace, who has interactions with a justice of the peace, who is part of a community where a justice of the peace serves, which is everybody in Nevada. If you don't know who your justice of the peace is, ask me afterwards and I'll help you figure it out. To ensure that there is some kind of frankly, a quality control mechanism to ensure that people who are sitting on the bench have a basic understanding of the legal requirements of their job and the matters that they'll be sitting over. And so this bill has gone through an evolution, as all good bills do, and I have worked closely with my colleague Elliot, with the judges of limited jurisdiction, with the Supreme Court, and with the administrative offices of the courts and the Judicial College to establish that this process, which we've kind of outlined in subsection 3 of section 1, that says that the Supreme Court and the Supreme Court will develop a test for all of these individuals to take within 18 months of being appointed or elected to office, and they have to pass that test in order to remain in their seat as a justice of the peace. The bill purposefully leaves the option open for that test to be administered by the Judicial College or as part of the Judicial College training, or to be a separate function. We've had really good conversations with both the Judicial College and the judges of this jurisdiction and the Supreme Court, all of whom are very willing and able to take on the task of creating the exam and administering the exam. So the idea is that if any one of you who is not an attorney and is still, entirely capable of sitting as a justice of the peace wants to run to become a justice of the peace in a jurisdiction where you don't have to be an attorney, which, by the way, is only places with populations of counties with less than 100,000 people. So we're talking about rural jurisdictions. If you were to live in a rural jurisdiction and you wanted to run for justice of the peace and you got elected to be that justice of the peace, you would be required to go to judicial college. And what SB 354 says is that at some point between the time that you get elected and the first 18 months of your service, in addition to going to judicial college, you would have to pass a basic exam, proving that you understand the laws that you're going to be tasked with implementing or enforcing, that you understand the obligations both ethically and legally of an attorney, and that you understand the ethics of a judge and the legal process that you'll be overseeing. And so the purpose of SB 354 is to ensure as we move forward that we continue to provide equal justice to everybody in the state of Nevada, and to ensure that voters feel confident that when they are electing somebody to the role of a justice of the peace, if that person does not have a law degree to fall back on, we have some other mechanism of ensuring that we're choosing people who will be able to faithfully fulfill the duties of that office. And so I'll turn it over to Mr. Malin for some more commentary.
Thank you. Good afternoon, Chair and members of the committee. For the record, my name is Elliot Malin. I'm grateful to be here alongside Senator Scheibel, who graciously agreed to bring this bill forward. Also, I'd be remiss if I didn't thank the stakeholders, as Senator Scheibel mentioned. We're great partners in crafting the amendment that is now SB 354. It's important to note that Article 6, Section 8, Subsection 1 of the Nevada Constitution vests the power to set qualifications of justice of the peace in this body in the legislature. As Senator Scheibel mentioned, in 2015, AB 66 revised the requirements for justice of the peace for townships and counties and population of 100,000 or less to obtain that position. Nevada's justice courts are courts of limited jurisdiction that hear criminal matters, which includes traffic violations, small claims, evictions, and civil matters up to about $10,000. The Justice Court also issues temporary and extended protective orders against domestic violence and or stalking and harassment. Nevada is one of 8 states that allows non-attorney justice of the peace to convict in certain criminal courts. This can raise some other right to fair trial concerns for certain Nevadans. Currently in Nevada, depending on the population of your township, your justice of the peace may not be an attorney. Their only formal statutory requirement is to hold a high school diploma. However, there are rules from the court that requires these justices of the peace to attend judicial college. Within these rules are currently nothing that require a justice of the peace to take and pass an exam showing that they retained a sufficient level of knowledge to adequately address issues before them. We seek justice at that standard with a minimalist approach. It must also be noted that this is not an attack on the justice of the peace in our rural communities. They provide a very important function. This is only saying that we should ensure that our citizens, our fellow Nevadans, are protected and given the opportunity to have a judiciary that works for them, that serves them. A judiciary that they can trust, knows the ethics and law required to make sound decisions on the bench. Today, 27 states permit non-attorneys to be justices of the peace, Nevada being one of them. Again, this bill does not seek to change that. What it intends to do is to establish a minimal level of comprehension of legal ethics and understanding of the laws that they will be seeing at the absolute bare minimum. Nevadans deserve to know that those that have the ability to make life-altering decisions for them understand these issues. While many have said that this bill does not go far enough, and trust me, a lot of my colleagues downstairs have said this, I believe this is a step in the right direction, and this is a minimalist approach to making sure that Nevadans are protected with a judiciary that works for them, and making sure that we actually have judges in those jurisdictions as well. So let me reiterate to make this very abundantly clear. This is just making sure that our justices of the peace are able to not only understand the issues before them and spot these issues. It's meant to protect Nevadans, the attorneys, the clients, and everybody that will be appearing before them. By having non-attorney justices of the peace take and pass an exam administered by the courts, this will ensure that our justices of the peace have the competency necessary to serve on the bench. That exam will be prescribed by the Supreme Court and must be passed within 18 months after taking the official oath, and will be required to test without limitation on judicial decorum, the application of the revised Nevada Code of Judicial Conduct, criminal and civil actions, and proceedings over with which a court has the Justice Court has jurisdiction, and the financial administration of a court We are just, again, trying to make sure that Nevadans have a judiciary that works for them and works for all Nevadans. So thank you, and I urge your support.
Thank you very much. Looks like we do have some questions, so I will start with Speaker Yeager.
Thank you, Madam Chair. Thank you for presenting the bill. I have a few questions. I think they're all pretty easy and straightforward, but I'll go ahead and ask them. How many times can someone take the test? Can they take it more than once in the 18 months, or is it a one-time only option?
Melanie Scheibel, for the record, it is unlimited, and part of the reason that we discussed an 18-month window is that if someone doesn't pass it the first time and they need to review certain sections of the Judicial College syllabus and go back and retake it, I think that they should be able to do that. But at some point, if somebody can't pass a test about the legal cases they're going to be presiding over, I think it's fair that, the citizens of that jurisdiction get another chance to select a justice of the peace.
Thank you. Follow-up, please. Next question is, do you envision, I know this is just for justices of the peace who are not licensed attorneys, but do you envision it would be the same test for everybody, or would the test be specific based on the jurisdiction that the person is serving in?
Melanie Scheibel, for the record, I would imagine that it would be fairly standardized. I could foresee some, sections being different for different justices of the peace, but generally their limited jurisdiction is set out by the Nevada revised statute. So I would think that we'd be able to, that the Supreme Court would be able to write one test that everybody would take.
And a couple more, if I could, Chair. Thank you. So, one concern I have is this. It would be a pretty, I don't know what the phrase is. I would feel bad for somebody who ran for election and won and then was like not able to pass the test, right? And they essentially, it sounds like they get booted off the bench 18 months in. I wondered if you'd thought about the option of letting someone take the test before they become a candidate for election, so they'd be able to at least have that locked up before they got their name on the ballot, campaigned, spent a bunch of money, although I think these races generally are a little cheaper than in our urban areas, but just wondered if that was contemplated in here, or if not, if that's something you'd be willing to entertain.
Melanie Scheibel, for the record, I would be happy to either in practice or through an amendment allow for someone to take the exam before they register, before they file to run for office. The reason that that the amendment includes the 18 months as opposed to having it be a requirement of running for office is that we learned that when we all filed to run, we went down to wherever we went. I went to the Clark County Commission, and I brought proof of my address and my identity, and the county elections officials weren't comfortable with making determinations much beyond residency requirements. And so we couldn't really come up with a good statutory way to empower county elections officials to determine whether or not people had passed the test and with a passing score, and how they were supposed to provide proof of that, when they were supposed to provide proof of that. We went through, should it be within 30 days of filing? Should it be within 30 days of winning? So that's how we ended up with the 18 months, within 18 months of election. I think it would be up to the Supreme Court whether they would allow somebody who hadn't been elected to also take that exam. I'm fine with it, but obviously I don't speak for them.
Thank you. And then last one, if I could, Madam Chair. I don't know the answer to this. I'm not sure if you do, and if you don't, I'm sure there's someone in the room that does. But I was wondering right now, for justices of the peace who are not attorneys, are they required? They have to go to Judicial College, I know that, but are they required to do continuing legal education classes every year? I'm getting some nods, some nods in the affirmative behind you, so it sounds like they are. So that takes care of my question, which is going to be, how do you account for changes in the law? But if that's already a requirement, then I think that satisfies it. So I didn't really have a question there, or not one that requires a response. So thank you for the time, Madam Chair. Appreciate it.
You are very welcome. Next, we'll go to Assemblywoman Gonzalez.
Thank you so much, and thank you so much for the presentation. I was curious, so if the elected person cannot pass the test and they are elected, so then what happens? Do we have to do a special election? Yeah.
Melanie Scheibel, for the record, that would be up to the individual jurisdiction. Even today, different jurisdictions have different ways of appointing temporary justices of the peace based on their internal mechanisms. And so it would be the same thing. That person would be considered unqualified for the office, and that jurisdiction would have to replace them through their normal process.
Thank you so much. So I guess I'm just struggling with the concept of those voters losing out on the people that they wanted to have elected and us saying that they are unqualified. You know, we don't take exams here, and I'm just trying to understand the issue. I'm not a judge. I'm not in this space. And so they don't pass the test, and then that jurisdiction would have the authority on if they want to appoint someone in the interim of that, and then would they have another election?
Melanie Scheibel for the record. So two things. First of all, I do want to point out, and your questions touches on this, that at least speaking for myself, what I envision happening with this is not that you will have people who don't pass the test. I think that, I practice in front of justices of the peace who are not attorneys. They are fantastic judges. I would not want them to leave the bench, and they will be grandparented in, for the record. But the purpose is to make sure that anybody who is taking on this job doesn't just go through the judicial college, and have that one directional instruction, but that there is a test on the back end to ensure that they retained it. And so I think that it is part of improving the judicial education for them. And what I'm hoping will happen is that everybody will take this seriously. They will attend judicial college. They will attend every day of judicial college. They will pay attention at judicial college. And that way they'll be able to pass the test and retain those seats. I think that, in the unusual case that somebody is really unable to pass the test, I think the two things. First of all, the purpose of the test is to give the voters a better barometer of, who they're electing to become a justice of the peace. Personally, I would like to know that, because we don't get a lot of information, and you'll hear about that in the next bill that I'm going to present. We don't get a lot of information about our judicial candidates. And so it would give me peace of mind to know that after they were elected, they fulfilled this requirement. But the other thing that I will say is that we do lose justices of the peace as it is, and they have to be generally, in most places, they'll be appointed to fill the rest of the existing term, and then the seat will be up for a normal election in the normal election cycle. And so that happens to voters already who vote somebody into office who then, resigns, retires, passes away, whatever the case may be, and they get somebody who's appointed instead.
Elliot Mallon for the record, and it's really important to understand that right now, these justices of the peace, their qualification for the judicial college, there's nothing that shows that they retained any information. It's just that they showed up. So we're sending them to judicial college. The counties are typically paying for that, and we don't know what they're learning necessarily. We know what the curriculum is. We just don't know if they've actually learned while there. We're trying to make sure that we understand that they are qualified. They understand what the job is, the qualifications are, and what they're going to be seeing. Thank you.
Thank you. Next, I have a question from Assemblyman DeLong.
Thank you, Chair. I think my questions have pretty much been addressed by the questions from the previous two members, but, so just a comment, this bill only applies to counties of less than 100,000. And there's no one on this committee that represents any of those counties.
Melanie Scheibel for the record. In fact, it only applies to people who are elected to the position of Justice of the Peace who do not hold a law degree. And many of our rural Justices of the Peace are, in fact, attorneys. It's just that, for whatever reason, in 2015, this legislature decided that it was fair to say that if you live in a county of over 100,000 people, your Justice of the Peace has to be an attorney. But if you live in a county of less than 100,000 people, the requirements are different.
Thank you. Next, we'll go to Assemblywoman Monroe Moreno.
Thank you, Madam Chair. With the Judicial College, is there testing procedures as they go through the college? Is there a test at the end of the, okay, so would it be easier to put a test at the end to make sure that the attendees were retaining what they were taught and have the test there?
Melanie Scheibel, that is the intent of the bill, is to allow for that test to be administered at the end of the judicial college. And it is purposely written with just enough room so that whether it's literally the last day of judicial college, or they want a week to study for it first, or the Supreme Court wants to be the one to administer the test, either way is fine. But the purpose is to have the test within 18 months of election, so they've already attended judicial college, and the test mirrors the judicial college syllabus.
Thank you. I didn't see that in the amended language, so thank you.
Melanie Scheibel, it doesn't spell it out explicitly. It doesn't mention the Judicial College in the amendment language, so I don't know how anybody would know that without having this conversation that we're having right now.
Thank you. Next, we'll go to Assemblyman Hibbets.
Thank you, Chair, and thank you for the presentation. Forgive me if I missed this in the initial presentation. In the subsection 3, it says examination prescribed by the Nevada Supreme Court. Has anybody checked with the Supreme Court to make sure they're okay with this?
Melanie Scheibel, I think it was their idea, but they are okay with this, and they will be here to testify in support or neutral.
Thank you very much.
Thank you. Next, we'll go to Vice Chair Miller.
Thank you, Chair. And I just wanted to follow up on my colleague's question. I guess what I believe a question may be, and what I'm looking for is, if we're talking about asserting a test for the completion of the Judicial College, why aren't we just requiring the test for the Judicial College and for everyone who completes that program, instead of, singling out individuals and districts and stuff like that? And I think many of us may be a bit surprised that there isn't already some assessment at the end of that program. So could you speak to why don't we just simplify it and make it, and that would cover anyone that would be required to go?
You're right, these don't really. Yeah. Elliot Mallon for the record. Thank you for that question. The reason why we did it this way, and that we worked with the stakeholders from the Judicial College and the Supreme Court and the courts of limited jurisdiction, was it gives the court the platitude to work with all of them in the interim to make this exam. And the other part of that is we also don't want to handcuff the Judicial College into, as we talked about, within 18 months of being elected. If we were to do it, we could handcuff them, and I would be uncomfortable doing that as well.
Melanie Scheibel, if I could just add one more thing. I'll also just speak frankly to the process that we went through to get to this bill, which is that as legislators, we do set the qualifications for justices of the peace. I have not been involved in a bill before that tasked the Judicial College with any kind of curriculum change or told I don't know what our legislative authority or duties are over the Judicial College. And so I think it would be probably a different road to the same ends. And I'm open to a discussion about whether it's the better route to the same ends. But since we came at this from the direction of, qualifications for election, that's how we ended up being on a separate track from the Judicial College itself. But you could probably go that other direction and get to the same place.
Thank you, Chair.
Thank you. Assemblywoman Newby, I know you had a question, then I think it was answered. Just want to make sure. Okay. Does anyone else have any questions? Okay, seeing none, thank you very much. We will close the hearing or no, we won't close it. We're going to open up testimony in support of SB 354. Remember, please push the microphone and state and spell your name for the record. You may begin when ready. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. I'm here today in support of SB 354. In Nevada, justices of the peace preside over misdemeanors, traffic, evictions, and small claims disputes. Additionally, they oversee protection orders. In short, the cases that justices of the peace oversee have a pronounced effect on people's lives across Nevada. In some jurisdictions, only a high school diploma is required to run for the office of Justice of the Peace. This is a very low threshold for the seriousness of what they oversee. Adding the Justices of the Peace requirement to pass a multi-state professional responsibility exam is not creating an insurmountable barrier to running, but is raising the office's professionalism. I encourage this committee to pass SB 354. Thank you.
Thank you, and I probably should mention, sometimes you have to push these buttons 2 or 3 times before they actually work. Is there anybody else in Carson City who would like to come to the table in support? Seeing none, and it doesn't look like we have anybody in Las Vegas. Broadcasting, do we have anyone on the telephone?
Chair, there are no callers to testify at this time.
Okay, thank you very much. Then we will close testimony in support and open up testimony in opposition. Is there anybody in Carson City who would like to come to the table in opposition of SB 354? Okay, seeing none and still seeing no one in Las Vegas. Broadcasting, is there anyone on the telephone who would like to testify in opposition?
Chair, there are no callers to testify at this time.
Thank you very much. We will close testimony in opposition, open up testimony in neutral, and I see someone approaching. Please press the button, sometimes 2 or 3 times, and then state and spell your name for the record. Thank you.
Good afternoon, Chair, members of the committee. My name is John McCormick, John, last name McCormick, McCormick, Assistant Court Administrator at the Supreme Court, and as the Senator indicated, the Supreme Court is willing to administer the testing provisions. And just by way of note, the Chief Justice has been having conversations with the Judicial College on some of this, but again, as the Senator indicated, we didn't want to get too prescriptive in the language.
Thank you very much. Is there anyone else in Carson City who'd like to come to the table in neutral? Okay, seeing none and seeing no one in Las Vegas. Broadcasting, is there anyone on the phone who would like to testify in neutral?
Chair, there are no callers to testify in neutral at this time.
Okay, thank you very much. I'd like to come back to the table and say a few final words.
Just that I appreciate you hearing this bill and remain open to questions and conversations after the hearing.
Thank you very much. And with that, we will close a hearing on SB 354, and we will open the hearing on SB 418. Again, we have Senator Scheibel, so please begin when you're ready.
Hello again. Melanie Scheibel for the record. I'm the state senator for District 9. And I left the bill over there. And I'm happy to present to you with SB 418. SB 418 is a bill to help our judicial elections and empower voters to make informed choices when they are voting for district court judges. Well, actually everybody, but this started out as district court judges. So before I get too far underway, let me address the amendment that you hopefully see on Nellis. This amendment actually was adopted by the Senate Judiciary Committee on the other side, and through a clerical error, we adopted a different amendment on the floor. So I have talked to legal about it, and if you all will just pass the amendment that we also passed, that makes it easy and we're all good. Otherwise, we can find some other creative ways to go back and re-amend our bill. But I think that you will all agree that the amended version of the bill with the amendment that you see on Nellis is a great idea, and it will be an easy amend, do, pass vote, because here's what SB 418 does. SB 418 says that anybody who is running for office for a judicial race has to fill out a questionnaire that will then be published on the website of the filing officer or the elections officer's website for every single voter to see. Where this idea came from was that in every county in Nevada today, when judges are appointed, like we just talked about, we lose judges for various reasons. They get appointed to higher office, they retire, they leave, for whatever reason, they resign, and judges are appointed to the vacancies. When a judge is appointed to a vacancy, there is a fantastic panel of experts who reviews the applications from lawyers in the community who want to be appointed to the district court, and they have to fill out this approximately 15-page questionnaire. The questionnaire includes some biographical information, like where they went to school, how long they've been practicing law. It includes professional information, like the types of law that they've practiced, where they've practiced law, where they're admitted to practice law. And it also includes a questionnaire portion about their approach to the law and cases that they've worked on. I talked to members of that committee who helps to select the applicants who are then referred to the governor for appointment, and they all had the same thing to say, that they really, really value those questionnaires. One of the most valuable parts of the questionnaire I just mentioned is where candidates describe legal cases that they've actually worked on, because it gives the committee an opportunity to understand how that person thinks, what they think is important, and it's not about whether or not you agree with the position that their client had, but it's about understanding that this person litigated a complex case in front of the Supreme Court, or they litigated, a high-profile case, and they had to deal with the media, and they handled it with, dignity and integrity, things like that. And so what we wanted to do with 418 was to have every person who is seeking a judicial office fill out that same application, that same questionnaire that anybody seeking to be appointed would have to fill out, and then have the filing officer in the place where the person is seeking election post that questionnaire on their website. The questionnaire, as it currently is written, does have some confidential information in it that wouldn't be appropriate to share on the elections website. So the amendment to the bill that was accidentally adopted says that it will exclude the confidential information. The new and improved amendment says that the Supreme Court will provide the questionnaire. And so kind of like the test that they're going to prescribe for justices of the peace, it does give them some leeway to adjust that questionnaire, but we're not starting from scratch and reinventing the wheel. We're talking about a questionnaire that already exists with some modifications to be made to adapt from going to a panel to going to the voters. And that is the basis of SB 418. It was also amended to include judicial candidates beyond the district court. So it could include judges running for municipal court or justice court. And I'm happy to take any questions.
Thank you very much. Looks like my first question is Vice Chair Miller.
Thank you, Chair Gorlow. And my question goes back to the comment that you made about the questionnaire, and that one of the questions being about the cases that the candidates had worked on previously. And I know the initial response would be, well, they have a choice which cases they put on. However, my concern is also, and I know it's also public record, people can look it up, but the average Nevadan doesn't do that. They're just going by the information they have. My concern would be security. Judges are vulnerable people as well as anyone in the criminal justice system. And so I'm just wondering if you could speak on to that security issue, and also who, again, I don't think I was clear on who would develop the questionnaire, so that, who would, and the purpose, the purpose of it. But if you could speak to the security first.
Absolutely. Melanie Scheibel for the record. So it would be the Supreme Court that would be prescribing the questionnaire. And we encounter the same questions already with our judicial appointment candidates. They already fill out a questionnaire, which is made publicly available when it is submitted to the panel, for the panel to review and submit to the governor for their recommendation. And so I completely agree that we want to make sure that we're keeping parties to action safe. We want to make sure we're keeping judges and everybody else involved in the system safe. And so I think that would be number one, an important consideration for the Supreme Court and how they phrase that question and the kind of information that they ask for. But just speaking more in practice, having reviewed the questionnaires, they are general in nature. It's kind of like asking a legislator, talk about 3 bills that you're most proud of, or that were the hardest to get passed or something. They're not asking you to list every single person who you talked to and every single person who came in support or opposition. Same thing with asking a lawyer to talk about a case that they worked on. We're not asking for every single filing in the case or first and last names of litigants to a matter. We're asking for, in broad strokes, I handled this case where, the court ultimately upheld this rule or overturned this rule or something like that.
Okay, thank you very much. Then we'll go to Speaker Yeager.
Thank you, Madam Chair. Thank you for presenting the bill. A couple of questions. One, it says that the person must must file with the filing officer a questionnaire. Is the filing officer doing any vetting of that questionnaire? For instance, I mean, if someone's just like doesn't complete a question, or it asks for educational experience and they only put high school, they didn't put, because I think you have to have at least a high school degree to be a justice of the peace, but you have to be an attorney to be justice of the peace in some circumstances in a district court. So like is there any vetting there? Is it simply the test is you hand it in and they upload it to the website and you are now a candidate for judicial office?
Thank you for the question. Melanie Scheibel, for the record. The other qualifications would still exist in law for somebody to be eligible for whatever judicial office they're running for. This would be an additional requirement that they fill out the questionnaire and that the filing officer post the questionnaire online. But no, there is no requirement or expectation that the filing officer will be reviewing it for accuracy.
A couple more, if I could, Madam Chair. Thank you. I think you kind of answered, well, maybe didn't answer, but it indicates on the amendment, the proposed amendment, that the questionnaire is going to be on the internet website of the filing officer. So is that like I'm trying to think, if I'm a voter, like how do I know where to go, assuming I want to find this information, how do I know where to go to find that information about the questionnaire?
Melanie Scheibel again. Great question. And filing officer is defined in the Nevada Revised Statute, so that's why we use that term. And so it would be the same website that everybody goes to find out where early voting locations are and how to register to vote and to find their sample ballot. There would simply be an additional link, an additional option to review those questionnaires. And I have spoken to the county clerks and the county registrars of voters and the Nevada Association of Counties, and they are all fine with this requirement and also don't think that it would cost them, enough money to put a fiscal note on it. It's a fairly simple process to upload one additional document for those few races where it would be required.
Could I ask a couple more, please, Chair? So would this questionnaire, would it have to be signed under penalty of perjury or something like that? I mean, I'm just wondering, like, what's the consequence for somebody lying, misstating their qualifications? Like, is that contemplated here? And, I guess the second part of that is, like, who is the arbiter of that information in terms of its accuracy?
Melanie Scheibel, for the record, I think having them fill it out under the penalty of perjury is a great idea. I don't know if we have to put into statute that it's filled out under the penalty of perjury, or if the Supreme Court can include that in part of the questionnaire. And I think that, the question about the accuracy kind of goes to the questions that we always ask about candidates and their accuracy and their qualifications for a particular office. And I don't mean qualifications colloquially. I mean literally when a dispute comes up about whether somebody actually lives in their district or whether they've actually reached the age you need to reach to file for office, we have a patchwork of protections that allow voters and other people to challenge somebody's eligibility for a particular office.
And last one, if I could, Madam Chair. Do you envision that incumbents would have to do this as well, or would it just be for first-time candidates?
I would envision, Melanie Scheibel, for the record, I would envision that incumbents would be able to update their questionnaire each year once they've already filled it out. And that's how I envision this working.
I guess I do have one follow-up with that, Madam Chair. Well, I mean, so the bill would apply going forward, right? But we have incumbents that are serving now, so they haven't had to fill this out in the past. So like in the next election cycle, would all those people running for re-election have to fill out this questionnaire? Which, I mean, I'm not saying that they shouldn't, but at the same time, like, I think we kind of, well, I shouldn't say we agree, but like they're on the bench, they're doing the job. So would they sort of be exempt as long as they continue to be on the bench, or would they have to fill it out?
Melanie Scheibel, for the record. I'm not sure the answer to your question. I would defer to legal if they have an interpretation of the amended language.
Yes, thank you. So the amended language refers to a candidate. So an incumbent, when they file for a re-election, would be a candidate. And so it would apply to those filing for re-election, or incumbents filing for re-election. If there was a desire to change the applicability of that, that could certainly be done in the amendment.
Just a comment, not a question, I promise, Madam Chair. I mean, I do think that would be a good idea, I think, for incumbents not to have to essentially, validate themselves. But, that's a discussion for another day, and it's not a deal breaker for me. But at the risk of drawing the ire of my court friends out here in the audience, I think one of the challenges we have, right, is we have district court elections. In Clark County, we have like 85 seats on the ballot, right? And even the most astute voter, it's a lot to ask of them, even under the current regime, to try to vet all these different folks, and that's in addition to the rest of the ballot. And I know why we aligned all those seats on one ballot, but I just wish there was some way that maybe our voters wouldn't have to make choices in all of those races every 6 years for district court. But that's a discussion for another day. And so thank you, Madam Chair, for letting me ask all those questions and for the comment as well.
And if I may make a comment in response, Melanie Scheibel, and I hope that my intent is clear here to make voting easier for voters and not more difficult. The idea is not to inundate them with additional information to sift through, but to put all the information in one spot. Because I know when I go to vote for 75 judges at a time, even as a practicing attorney, I don't know all of them. And so in the races where I don't know the attorneys running, it can be onerous to try to look them up on the state bar website, go to their campaign website, ask around to all of my friends. And, the idea is to be able to, with a click of the button, get a questionnaire that gives me the basic information that I'm looking for, and then move on to the next candidate and go through that with each one, since judicial elections, they're different from other types of elections.
You're very welcome, Speaker. We'll go to Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you for the bill presentation. I, too, struggle sometimes when I'm trying to make judicial selections on my ballot. I wanted to, though, go back to the amendment, because your subsection 2 that you're striking kind of threw me off. So you're essentially deleting the whole bill and then replacing it with your new section 1. Is that correct?
That is correct, Melanie Scheibel, for the record.
Okay. And is the section 1 deleted, you mean to delete that from NRS or delete it from your bill?
Melanie Scheibel, for the record. Excellent question that I meant to clarify earlier. We're not deleting that section 1 from the NRS. It's only being deleted from the bill. So it'll remain in law, because those are the rules about how you become qualified to run for district court judge. So yes, that's to be deleted from the bill, not from the revised statutes.
Thank you. That was concerning.
Thank you very much, Assemblywoman. Are there any other questions? Okay, Assemblyman Hibbets.
Thank you, Chair. Thank you, Senator. It's my understanding that the purpose of this bill is to provide more information for the populace to make an informed decision. And while I am ecstatic about having more information for people to know about judicial candidates in particular, we don't do this for any other elected office. Why should we think that justices of the peace or municipal court judges or district court judges are special?
Melanie Scheibel, thank you for that question. Judges, including judicial candidates, have different codes of conduct and ethics than the rest of us when we run for office. When we run for partisan office, we get to stand up on a soapbox and tell people exactly what we think about everything. We get to talk about policies and how we would vote on issues and where we stand. Judges do not get to do that. Any candidate for judge who would come out and tell you where they stand on a political issue is a bad candidate for judge. I'll say it, okay? Don't vote for that person. So judges are in a very difficult, I think, in a difficult position. If you want to be a judge and you have to put your name on the ballot, but you can't go out and rely on your party platform. You can't organize around the grassroots issues that all of us organized around to get elected. All judges can do is go from one event to the next and say, I have this much experience. I promise I'm fair. I'm a good person. Please vote for me. And I think we do them a disservice by not having another platform where they can speak directly to voters in the way that matters and in a way that voters are able to hear and evaluate what they have to say. Because I have been to panels where, judges sit, or the judicial debates that the Review Journal has hosted in the past. And they're great for the few really invested voters who actually take the time to watch those or attend those. And this is to try to get to those, kind of in the middle people. They're not quite invested enough to go watch 18 hours of judicial debates, but they're invested enough to click the link and read and see where this candidate went to law school and how long they've been living in Nevada and what their practice area has been. And so I think that there is a special lack of knowledge in judicial races because they are not just nonpartisan, but they're supposed to be impartial jurors when they are elected. That makes for makes the information gap wider. And that's why we should treat them differently and have these questionnaires for judicial candidates that we don't have for other candidates.
Thank you, Senator, and thank you, Chair.
Thank you. Committee members, any other questions? Okay, seeing none, we will open up testimony in support of, what number are we on? 14. Thank you. SB 418.
Thank you.
Please go ahead when ready.
Thank you, Chair Gorlow, and members of the committee. My name is Chase Whittemore. Argentum Partners today appearing on behalf of Morello Gaming. We very much like to thank Senator Scheibel for bringing this bill and the amendment forward. Also like to thank the stakeholders that had some help in drafting the amendment as well. We really think this bill is a solid step in the right direction. To give voters access to more information about judicial candidates is extremely important. I'm an attorney, and as an attorney, every couple years I get the same phone call from about 20 to 30 friends and relatives. It always goes about the same. Chase, you know the judges. You're in politics. You do campaign work. You're an attorney. Who should I vote for judge? I'm sure some of you get those same calls as well. But that's the point of this bill, is voters all over the state face the same issue each election cycle. Information on judicial candidates is just hard to come by. So we believe providing more information to voters about a candidate's education and work history will ultimately improve the judiciary. So again, I urge your support of this bill, and maybe I'll get less phone calls next election cycle. Thank you for your time and consideration.
Thank you very much. Is there anyone else who would like to come to the table in support of SB 418 in Carson City? Okay, seeing none, we'll go to Las Vegas. Seeing nobody there. Broadcasting, do we have anyone on the telephone?
Chair, there are no callers to testify at this time.
Thank you very much. We will close testimony in support of SB 418. Open up opposition. Is there anybody in Carson City who'd like to come to the table to testify in opposition? Seeing no one, we'll go to Las Vegas. Seeing no one. Broadcasting, do we have anyone on the telephone in opposition?
Chair, there are no callers to testify at this time.
Okay, thank you very much. We will close testimony in opposition and open up testimony in neutral. Is there anybody in Carson City who'd like to come to the table in neutral for SB 418? Okay, seeing none. No one in Las Vegas. Broadcasting, is there anyone on telephone who'd like to testify in neutral?
Chair, there are no callers to testify at this time.
Okay, thank you very much. We will close testimony in neutral, and I'll bring the, nope, we're good. All right, we will close the hearing on SB 418. Thank you very much for spending time with us today. Appreciate you, Senator. Okay, if you do have an old agenda, next was going to be SJR2, but we're not going to hear SJR2. That was pulled by the sponsor, so we will move on to public comment. Each person has 2 minutes to provide public testimony, provide comment, A written public comment may also be submitted to the committee up to 24 hours after the meeting. If you would like to give public comment, please come to the table in Carson City. Seeing no one, then we will go to Vegas. We have no one there. Broadcasting, do we have anyone on the telephone who would like to provide public comment?
Chair, the public line is open and working, but there are no callers at this time.
All right, thank you very much. Then we will close public comment. Committee members, any other comments or? Nope. All right, seeing none, we will see everyone back here at 4 o'clock on Thursday. Be good to each other, and we are adjourned.